The Supreme Court on Wednesday hears a challenge to the Voting Rights Act of 1965, widely viewed as one of the most consequential laws in American history. Its detractors say the Voting Rights Act is out of date. Its defenders consider it a needed bulwark for justice.
Today, we strike away the last major shackle.
When he signed the Voting Rights Act in 1965, President Lyndon Johnson called it a triumph for freedom. It had been a century since the Civil War and constitutional amendments extending the right to vote to former slaves and granting equal protection of laws. But in some places in the South, states had imposed barriers, like poll taxes and literacy tests, making it harder for African Americans to vote.
Morality cannot be legislated, but behavior can be regulated.
For the past half-century, the Voting Rights Act has been a tool for the federal government to prevent racial discrimination. Now, the Supreme Court is reviewing Section 5 of the Act, which requires all or part of 16 states to obtain Justice Department approval before changing voting laws or maps. Some states, like Alabama, where the case originated, say Section 5 is an outdated burden, that discrimination is scattered and limited. But the Act's defenders say it's as relevant as ever. They cite recent state laws limiting early voting or requiring voters to get government-issued photo IDs. Attorney General Eric Holder relied on the Act to challenge South Carolina's voter ID law last year.
Protecting the right to vote, ensuring meaningful access, and combating discrimination must be viewed not only as a legal issue, but as a moral imperative.
In 1965, President Johnson said he hoped the Act would guarantee the right to vote unrestrained in every precinct in the country. And Congress has endorsed that notion by reauthorizing the Act 4 times, most recently in 2006. Between 1982 and 2006, the Justice Department used Section 5 a total of 2,400 times to block what it considered discriminatory voting law changes in the states. For more on the upcoming Supreme Court hearings, we are joined by our chief legal correspondent, Jan Crawford. So, Jan, is the argument from the folks who don't like Section 5 that racial discrimination no longer exists?
No, and they are not attacking the entire Voting Rights Act. If there's intentional discrimination, people could still sue. But as you pointed out, they're challenging Section 5. That requires Alabama and other mostly southern states to get federal approval before they change their voting laws or requirements, even things like where polling places are. They say that provision may have been necessary 48 years ago, but today there's no more racial discrimination in voting in Alabama than there is, say, in Michigan or Ohio. So why should Alabama and those states be treated like it's still 1965?
So, Jan, I know you're going to be there on Wednesday. In your estimation, who has the more difficult case here?
Well, I think both sides are going to have a tough argument. The justices heard a similar challenge a few years ago, but they sidestepped this big constitutional issue. But then several of the justices seemed skeptical of this provision. Chief Justice John Roberts said that the people who were defending Section 5 seemed to think that Southerners discriminate more than Northerners. But, Jeff, this is not an easy case. Congress in 2006 said the law was still necessary, so you can expect the liberal justices to say the court should still defer to Congress.
Jan Crawford, thank you.